Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is based on the jurisdiction of the High Courts to entertain the writ petition. The issue before the Honorable Bombay High Court was that if the notice to the assessee has been issued by an assessing officer who does not belong to the Bombay but the assessee is from the Bombay, so whether in that case the assessee has a right to file the writ petition in the Bombay High Court, or whether this writ petition should be allowed on the basis that the assessee do have the right of filing the writ petition in Bombay High Court. And the second issue was that if the company has been amalgamated and the assessee has duly intimated to the learned assessing officer about the amalgamation of the company, so whether in that case the notice issued to a non-existing entity is valid in the eyes of the law. These both issues were taken up by Honorable Bombay High Court in the case of Uber India Systems Private Limited versus Assistant Commissioner of Income Tax, and this case is reported in 483 ITR at page number 771. The date of the judgment is 8th October 2024 and the assessment year belongs to assessment year 17-18. In the present case, the notice was issued by the assessing officer outside jurisdiction of Bombay High Court. The assessee was within the jurisdiction of Bombay High Court. When the notice to the assessee under section 148 was issued for the reassessment, the assessee challenged this notice in the Bombay High Court through a writ petition that this notice has been issued to a non-existing entity, so it should be quashed. The revenue defended this notice firstly on the ground that in the present case the Bombay High Court is not the jurisdictional High Court of the assessee. The reason for taking this plea was that the notice has been issued by an assessing officer which is other than the assessing officer of the Bombay. When this matter was heard by the Honorable Court, the court said that in the present case the petitioner was required to defend the notice in Mumbai, part of cause of action arising within the jurisdiction of High Court. Since the assessee is living in Bombay, so he has every right to approach to the Bombay High Court. So as far as the maintainability of the writ petition in the Bombay High Court was concerned, the court was very clear that once the assessee is living in Bombay, he can approach to the Bombay High Court, because the assessee do not have any right or control over the issue of the notice by any assessing officer which does not belong to Bombay. So if the assessee is living in Bombay, he can well approach to the Honorable Bombay High Court. As far as the second issue was contested, which was the merit of the case, the assessee was contesting that the company of the assessee has been amalgamated. It is a well settled issue now that if the company is not in existence, but the prime condition is that if the assessee has intimated to the AO about the amalgamation, then any notice issued to the amalgamated company will be bad in law. Sometimes it happens that the assessee has not intimated to the AO, and assessee takes the plea that when the amalgamation was done, the department was asked by the NCLT to give the no objection for the amalgamation. So the department was already in the possession of the information that the company has been amalgamated. For this, the court has to say that if the no objection is asked, so it may be the situation that the company is not amalgamated after the no objection, or the no objection is not given. So for extra precautious, it is the suggestion that whenever a company is amalgamated, or whenever there is death of any assessee, or when there is a question of non-existence of any entity, then it should be duly intimated by the assessee to the assessing officer. Then any notice issued to a non-existing entity becomes itself bad in law. At the end of this video, once again I am repeating the name of the case. The name of the case is Uber India System Private Limited versus Assistant Commissioner of Income Tax, and this case is reported in 483 ITR at page number 771, and the date of the judgment is 8th October 2024. Thank you, friends.